Welcome to Law Made Simple, where we break down complex legal issues into simple, actionable insights. Today's topic is one that affects every working professional. Can your employer legally monitor your WhatsApp or email? What are the boundaries between workplace oversight and personal privacy? And if you're searching for a new job, can your employer find out and fire you? We'll explore the legal framework, real-life examples, and remedies available to employees in India. This episode is especially important for anyone working in tech, startups, or remote setups. We'll also share best practices to protect your digital privacy at work. Stay with us till the end for practical tips and legal safeguards. And if you find this useful, don't forget to like, share, and subscribe. Let's get started. In most workplaces, employers monitor official email accounts to track productivity and compliance. They may also review browsing history if you're connected to office Wi-Fi. WhatsApp chats on company-issued phones can be accessed, especially if used for client communication. Internal platforms like Slack, Teams, or Zoom are often logged and archived. Some companies even track your location using apps or access cards. This kind of surveillance is usually justified as a security or workflow measure. But it raises serious questions about consent and privacy. Are you being watched without knowing it? And what happens if personal conversations or job searches are discovered? Let's look at what the law says. In India, your right to privacy is protected under Article 21 of the Constitution. The landmark Puttaswamy judgment in 2017 made privacy a fundamental right. This means even employers must respect personal boundaries. Under the IT Act, Section 43A deals with data protection, while Section 72 penalizes unauthorized access. The SPDI rules require companies to obtain consent before collecting or sharing sensitive personal data. Your employment contract or IT policy may include clauses about monitoring. But consent must be informed, voluntary, and specific. Blanket surveillance without disclosure is not legally defensible. So always read your onboarding documents carefully. Let's now look at WhatsApp, one of the most misunderstood areas. WhatsApp monitoring depends on the device and context. If you're using a company-issued phone, your employer may legally access WhatsApp chats. Especially if it's a WhatsApp business account used for client or team communication. But if you're using your personal phone, the employer cannot monitor your chats without consent. Even if you're connected to office Wi-Fi, your private messages are protected. BYOD, bring your own device, policies must clearly define what's monitored. Ambiguous clauses don't hold up in court. If your employer accesses your personal WhatsApp without permission, it may violate Section 72 of the IT Act. Always separate work and personal communication. Let's move to email, another common surveillance tool. Monitoring official work email is generally allowed, especially if the company has a documented IT policy. Emails sent from your @company.com account may be logged, archived, or reviewed. This helps prevent data leaks and ensures compliance. However, personal email accounts like Gmail or Yahoo are off-limits. Unless you've explicitly consented, your employer cannot access them. Even if you open Gmail on a work computer, they can't read your emails without breaching privacy laws. Section 72 of the IT Act protects against unauthorized access. Make sure your employment contract doesn't include vague clauses about all digital activity. If in doubt, ask HR for clarification. Now let's talk about job hunting. Can it get you fired? Imagine you're quietly searching for a new job during your lunch break. You use your personal phone, personal email, and don't breach any company policy. But your employer finds out and fires you. Is that legal? In most cases, no. Job hunting is not misconduct unless it violates specific contract terms. If you're terminated without notice or valid reason, it may be unlawful. You can file a complaint with the Labor Commissioner. You may also seek damages for breach of contract or wrongful termination. Keep records of your job search and communication. And never use office email or devices for personal job applications. Let's look at a real case from Bengaluru. In 2022, a Bengaluru-based tech firm abruptly terminated over 200 employees. No notice was given, and no severance pay was offered. The employees filed a collective complaint with the Labor Commissioner. The company was found to have violated labor laws. As a result, compensation was awarded to affected employees. This case highlights the importance of due process in termination. Even in private companies, labor protections apply. If you're fired unfairly, don't hesitate to seek legal help. Document everything: emails, chats, and HR communication. Your rights don't end when your job does. As an employee, you're entitled to a formal notice period or notice pay. You must receive a written termination letter stating the reason. All pending dues, gratuity, bonus, leave encashment, must be settled. If you're terminated unfairly, you can challenge it in labor court. You may also file a civil suit for breach of contract. Don't rely on verbal promises, ask for everything in writing. Keep copies of your appointment letter, salary slips, and emails. Legal remedies exist, but documentation is key. Consult a labor lawyer if you're unsure. Let's wrap up with some preventive tips. To protect your privacy, always use personal devices for job search. Avoid using office email or Wi-Fi for personal matters, it's safer and smarter. Read your company's IT and HR policies thoroughly, and if anything seems vague or intrusive, ask for clarification. Keep records of important communication, especially related to performance reviews or HR discussions. Don't mix personal and professional accounts, it can lead to unnecessary exposure. If you're terminated unfairly, act quickly. Consult a lawyer and file a complaint with the Labor Commissioner. Your digital habits can protect or expose you, choose wisely. If you found this video helpful, please like, share, and subscribe to Law Made Simple. And if you know someone who's facing this situation, share this video with them, it could make a real difference. We'll be back soon with more legal explainers to keep you informed and empowered.